Yes, Mr. Gardner.
My Lord, two very small points your Lordship asked me this morning. That part of the Income and Corporation Taxes Act that is headed tax avoidance runs from section 703 to section 787 at the time.
Could you give those numbers again? I'm sorry.
703 to 787, my Lord, at the time. It's much expanded over the last 10 years, but for the purposes of 2001, 2002, it's some 84 odd sections. And obviously there are all the schedules to back that up, but I've just given you the section numbers. And the other point was that you asked me about the amendment that I was saying was relevant possibly to paragraph 13. It's actually an amendment to section 97, and it was made by the Finance Act 2002 with effect from the 1st of September 2002. So it could not have any application to this case, and I'll add the details of it to the paper that we're producing tonight. Yes. But the point of it, as you can see in the explanatory notes, was to make sure that Section 97 produced a loan relationship, and the explanatory notes say, for the purposes of paragraph 2 and paragraph 13. So the thinking was that it didn't actually enact a loan relationship for the purpose of paragraph 13. So if I then return to where I was, I'd made my first general point about the structure of the legislation and the detail of it, and that was where paragraph 13 was relevant. And then my second point was the revenues complaint here is that we don't end up with a result that is the economic result in the accounts. And I was simply saying that if we had legislation structured on that particular basis, then obviously that would be a valid complaint. The problem is that we don't have legislation based on that premise. And I was just going to ask your Lordships to look at one or two observations by Mr. Justice Norris and Lord Justice Rymer and indeed Lord Justice Moses, the courts below, about the structure of the legislation. And I'll do this very quickly, but it might be just worthwhile if I just said to your Lordships, Mr. Justice Norris, it's paragraphs 8, 9, 21, 22, 31.
I'm sorry, could you...
Yes, I'm sorry, I think two quickly. 8, 9, yeah. 21, 22, 31, 44, 45 and 48. And I won't take your Lordships through them, but just to get the flavour of them, if I could just show your Lordships paragraph 31. And here he's rejecting a submission of mine about the effect of paragraph 15. But he is making what I accept to be a valid observation as to the structure of this legislation. Paragraph 31, you can see it refers to the construction of paragraphs, sorry, page 86 of part 1 of the appendix in the core bundle. And I'd made a submission about paragraph 15 that it was attempting to mirror the accounting treatment under FRS 5. And he says at 2, 4, 5 lines down, he says, paragraph 31, that is simply because, he rejects that, and he says, but that is simply because the Taxes Acts proceed in this respect, not on the footing that tax is to be charged by reference to the economic profit as apparent from a company's accounts, prepared in accordance with GAAP, but on the footing that tax is to be charged on deemed income flows created by the application of a succession of hypotheses required by the Tax Acts. The statute does not adopt accounting practice. It seeks to achieve the same result, but by a wholly different means. And then, if I just go on to paragraph 44, he's here dealing with both section 730A and 737A5. And again, just to pick up one very simple little paragraph, it's about 8 or 9 lines down paragraph 44. Yeah, he starts the sentence at the left-hand side of the page. These provisions, and he's talking about 730A and 737A, do not recharacterise the coupon. They create a fictional sum, the deemed manufactured interest, numerically equivalent to, but different from the coupon, and quite possibly payable at a different time. And then he says in 45, but what of the deemed manufactured interest itself? This falls under Schedule 23A, to be treated under Section 97. The deemed manufactured interest which DCC has taken to have paid is for the purpose of Chapter 2, is to be treated as if it were interest under a loan relationship to which DCC was a party, Section 97.2a. There is thus another deemed loan relationship, one under which DCC is the borrower. This has no correspondence to any real event, and no trace of it can be found in the statutory accounts or books of DCC. The deemed manufactured interest which is treated as if it were interest under a loan relationship paid by DCC is an entirely fictional creation of the statute. So that's what he's referring to as far as Section 97.2a is concerned. And he makes the point in 48. He says, so far as the deemed manufactured interest is concerned, this is treated as an interest payment made by DCC on the repurchase date. What sums under the accruals method will, when taken together, fairly represent the gains or losses under this deemed loan relationship. The answer will not be found in any accounts because the transaction is entirely fictional. The answer seems to me to be 28.8 million. This is the amount of the deemed interest, and it cannot relate to any period other than the period for which the relationship between DCC and X-Bank existed, under which the deemed interest is deemed to be paid. That is the period of the repo transaction. This began and ended in the same accounting period, so the accruals method does not require it to be apportioned over any other period. A debit of 28.8 million must therefore be entered in the computation. So there he's looking at the deemed fictional income flows and making the point that they are deemed statutory fictions of a payment of interest under a loan relationship. And he's contrasting that situation with the situation in the statutory accounts. And it's quite noticeable that when he's concerned with, for example, the Section 97 loan relationship, he's recognising that the statute is creating a loan relationship under which DCC is the debtor, the borrower, the person paying the interest. And that is completely the reverse of what the accountants recognise in the statutory accounts. Because in the statutory accounts, the accountants recognise the substance of the transaction as being a loan by DCC on which it earns interest. So one can see that if you are making a comparison between the statutory accounts and, for example, Section 730A, one can see that there is a commencing premise that is consistent. And that's why they arrive at a consistent result. But the accounting treatment, which represents the substance of the transaction, has nothing whatever to do with the deemed fiction under Section 97. And the deemed fiction under Section 97 has got nothing to do with the accounting treatment, because it's the actual reverse of what the accountants recognise. It's creating an indebtedness of DCC, which neither in law nor in substance existed. And Lord Justice Rymer agreed with him, and I'd like to just briefly look at the Court of Appeal at paragraph 86 of his judgment. In the core bundle at page 23, part 1, the appendix.
Yes.
And it's really his conclusion. He refers to me and my submissions and said it conceded, indeed asserted, this much amended legislation is a mess. He was right to do so, and it comes as no surprise to me that legislators complicated this, which, following Mr. Justice Norris's decision, is the subject of proposed further amendments, has led to the result that I find it has. As Justice Norris said of it in his judgment, saying he's adopting this paragraph, something of a disgrace that in order to work out the tax consequences of an entirely ordinary commercial transaction, one must refer to about 20 closely articulated specific statutory provisions replete with cross-references, and is a matter of no great credit that the eventual method of charging tax is to postulate a notional sum paid under a hypothetical obligation, which notional payment is then itself treated as if it was something else, so that it can be deemed to affect the repurchase price and create a fictional income flow. Having entered into such a maze of hypotheses, notion, fiction, and deeming, it would be no surprise to discover that the draftsman did not find himself quite where he intended or facing the direction he thought.
Is it really an ordinary commercial transaction?
No idea. Well, that's right. On the statement of agreed facts, this is agreed to be an ordinary commercial transaction entered into at arm's length prices. And I don't shrink from saying that the legislation is a mess. I mean, it's now all gone. I mean, at last Parliament was attempted, as you can see in our case, to amend these provisions year after year after year. I mean, you can take any one of them and you can look at numerous amendments all the time, and eventually in 2007 they realised they'd had enough of it, they got rid of the whole lot, and they enacted legislation which comes down to taxing you on the accounting profit in your accounts. And that's the problem with all this legislation. It's no great pleasure to say it, but that's what we've got to face up to. And that unfortunately, is the legislation that is the subject matter of this case. And I think I should just refer your Lordships to Lord Justice Moses. He makes the same points, really, at paragraphs 56 to 60. If I could just perhaps pick it up at 55. In paragraph 55, he says, in striving for such a result, and he's here referring to the Special Commissioner who said, judgment and common sense and an eye to the recognition of profit or loss by those statutory accounts. And that's what he was trying to arrive at as a solution. And if you were trying to arrive at that solution, you obviously would arrive at the solution of the statutory accounts. But that's not what you're permitted to do by the statute. And then Lord Justice Moses says on page 17 of Part 1 of the appendix in the Court Bundle, he said, in striving for such a result, the Special Commissioner took the view that, and this is a quote from the Special Commissioner, paragraph 200, neither paragraph 15, section 730A, nor section 97 requires reality to be adjusted. No payments are deemed to be made which are not made, and no transaction is deemed to take place which does not take place, and no transaction is deemed not to take place which does take place. Then Lord Justice Moses says, I agree with Mr Gardner and with Mr Justice Norris. The provisions of section 730A, 737A, schedule 23A and section 97 do not admit of such a view. That section 730A deems ex-bank to have made a payment of interest to DCC of 1.8 million. No such payment was made. Section 737A, schedule 23A and section 97 deem DCC to have paid interest to ex-bank. No such payments were made. There is no basis for starting with an assumption that Chapter 2 is seeking to tax the economic profit shown in DCC's statutory accounts. On the contrary, the statutory regime deliberately and persistently creates fictional streams of income which would never appear in such accounts. He then goes on to deal with various arguments of the revenue, and he refers in paragraph 58 to the decision in the Bank of Ireland case, and I'll come to that later, but concludes at paragraph 60. Accordingly, I agree with Mr Gardner that the only legitimate approach is to construe the relevant statutory provisions and apply the result which they give without any assumptions. And all of that passage of his judgment, we would gratefully adopt. What it comes down to, and I'll come to Lord Justice Ricks in a moment, but looking at those three, the argument of the revenue is that somehow you should end up with the right result, which is the economic profit. That is really the wrong approach in our respectful submission, because it's starting with the result that you should try to get to, and then let's try to find some kind of way of getting to that result. The correct starting point is to start with the words of the statute and try to divine from the words of the statute what their purpose is and what they're trying to achieve.
But do we not still, however complicated it is, assume that Parliament is trying to produce a sensible and rational result?
My lord, yes, and sometimes Parliament may not have achieved that, even though it's tried to do so. And what one would say here is that it cannot be a justification of the provisions that we are particularly looking at, which is 737A and Section 97, to say that their purpose was to tax the economic profit. Because that purpose has already been achieved by Section 730A. It must have been an additional purpose. Now, whether Parliament actually knew what it was doing, or whether it was actually going too far, is a matter of conjecture. But at the end of the day, Parliament actually has enacted that legislation. And at the end of the day, for better or for worse, we actually have got to deal with that legislation, construe it as best we can, having regard to the words. And I agree, if it were possible to get out of those words what would be a sensible result in this case, and there were a choice between such courses, then that would be a course which one would adopt. But what I am saying is that it cannot be a justification to say you want to tax economic profit, because that can't be right. What therefore one has to accept is that the purpose of 97 and 737A was to tax an additional income flow. Once you've got to that point, it has to follow, it seems, in my respectful submission, to be that it must have been the purpose of Parliament to create an additional income flow over and above the economic profit of the transaction. Because otherwise, one's simply not paying attention to the words enacted by Parliament, and what one is driven to, the consequence of those words. It's not a literal or a literalist construction. I mean, I've spent all my life trying to divine the purpose of words enacted by Parliament, and all I can say of 737A and Section 97 is they were manifestly intended to create fictional loan relationships with income flowing under them so as to tax them. And it may be a phobia of the revenue, of disliking capital transactions, that they've gone too far and promoted legislation that has created too many income flows. But undoubtedly, the legislation has created those additional income flows. And the critical one, in every sense in my submission, is the one under Section 97. And apart from the Special Commissioner, who, as I say, was on a frolic of his own because he really disregarded all the statutory provisions and just said the answer is in the statutory accounts, and this is the point I'm trying to make, you just can't find the answer in the statutory accounts. But apart from the Special Commissioner, everybody's agreed that Section 97 creates a debit interest of 28.8 million on a loan relationship under which DCC was the debtor and the payer.
And you say there's no ambiguity in Section 97, which one might construe against you. The words are plain enough, and one simply takes what one finds.
Yeah, and nobody, other than the Special Commissioner, who didn't tackle it on the basis of ambiguity, just said all the answers are in the accounts. So he's not tackling it on the basis of ambiguity. But everybody else, every judge below who's actually looked at this, has come to the conclusion that the only conclusion from 97, from 97.2a, is that you've got a debit of 28.8 million of interest payable by DCC on a loan relationship to which it is the only party. And again, I mean, if we're looking at Lord Justice Moses, he puts his finger on it. I mean, very aptly in paragraph 51. This is where he's dealing with my learned friend's argument on Section 97. And perhaps if I perhaps just read paragraph 50, the key answer is the answer Lord Justice Moses gives in 51. But to get the context, in paragraph 50, he records Mr. Furness as sought to gain advantage from the application of an accruals basis of accounting to the interest expense DCC is deemed to have incurred. He attempted to achieve the revenue's goal of matching the sum representing the deemed manufactured payments to the sum representing the coupons on the gilts by applying an accruals basis not just to the amount brought into account in respect of the coupons, but applying that accounting method to the amount in respect of the deemed manufactured payments, That's the 28.8 million under section 97. If on an accruals basis only that proportion of the coupon which accrued during the period of the repo is to be brought into account, then Mr Furness contends only that proportion of the deemed manufactured payments deemed to have accrued as an expense during that period should be brought into account. After all, since the deemed payments are representative of the coupons, section 97(1)(b), and since section 97 is silent as to the period to which the deemed manufactured payments relate, there is every room, so he claimed, why an equal proportion of the deemed manufactured payments should be deemed to have accrued over the same period as the proportion of the coupons accrued. So there's my learned friend's argument, and here is Lord Justice Moses' answer. The answer to that submission lies in the underlying rationale of the accruals basis of accounting. In relation to the interest on the gilts, other persons will have been accruing interest in respect of periods outside DCC's ownership of the gilts, whilst they themselves were parties to the loan relationship represented by the gilts. Conversely, the deemed expense incurred as a result of the deemed manufactured payments could only be incurred by DCC and thus only accrued to DCC. The deemed manufactured interest is not, as the judge put it, notionally payable in respect of any period other than the period of the repo, the period when DCC was in a deemed loan relationship with X-Bank. And that's a reference to Mr Justice Norris at paragraph 57. So what the Lord Justice is saying there is that section 97 is creating a payment of 28.8 million interest by DCC under a loan relationship to which it is the only party. On an accruals basis, that must mean that the whole of that 28.8 million accrues to DCC because there is no other debtor under that relationship liable for any payment of any interest. And those are the clear and unambiguous words of section 97.
Where he says at D, if on an accruals basis only that proportion of the coupon which accrued during the period of the repo, is that a reference, what figure is that a reference to?
At D, my lord, this is Maloney from Mr Furness's
Yes.
argument. Yes, what he's doing is mixing and matching here. He's comparing the taxation of the taxation of the gilts, and as far as the taxation of the gilts are concerned, DCC only held the gilts for 18.5 days of the 6-month period.
Right.
Therefore, on an accruals basis, DCC can only be treated as accruing 18.5 over 182.5 worth of the 6
Well,
months.
that's the 2.9 million.
That's the 2.9 million. That's the taxation of the coupon on the gilts. That is a separate loan relationship from the loan relationship that the argument is about here, which is the section 97 loan relationship. The relationship on the gilts is the relationship where DCC is the creditor and is bringing in a credit on an accruals base of 2.9 million. The relationship under section 97 is completely different. It is a deemed statutory relationship whereby DCC is the debtor, not the creditor, the debtor, and is deemed to pay 28.8 million. And since DCC is the only debtor under that relationship, then the whole of that 28.8 million must accrue as a debit to DCC. What my learned friend is trying to say is that in the tax computation of DCC, we've got what he would call a mismatch. We've got a debit under section 97 of 28.8 million, and we've only got a credit under the gilts loan relationship of 2.9. To get to where he wants to get to tax on the economic profit, he's either got to knock down the 28.8 to 2.9, or he's got to increase the 2.9 up to 28.8. And that demonstrates that all he's actually doing is starting by the result he wants, not from the words, but by the result that he wants, and says, well, either way, whichever way it is with the figures, these two have got to cancel each other out, because that gets him to the result he wants. And we said that cannot be right, because if that were right, it would manifestly follow that Section 97 is a completely spent force, because its only operation will always be to knock out an equal and opposite contra item on the securities in question. And the Parliament would have enacted statutory provisions taxing the gilts loan relationship and enacting Section 97, and the only purpose of those two provisions was to knock each other out. And that cannot be right, and it's also important to
But
notice
it isn't right, is it? Because you agreed before lunch that Section 97 applies to a whole lot of transactions apart from repos.
Well, yes, but if I was looking in this particular situation, that would be the consequence of 97. It would always bring a conclusion at the end of the day whereby you didn't actually have any kind of debit. And 97.4 is a reference and enacted only for the purpose of repo transactions.
I mean, using the 2.9 figure, that's his alternative argument, is it, which he's advancing here.
Yes, that's his final alternative.
Yeah, I follow that.
Lord, yes, that's right.
Yeah.
But I mean, what that demonstrates, I'm merely saying, is that all he's looking at is the results of the case. He doesn't mind about the figures, he doesn't mind about the statutory provisions, provided he gets a result that a credit knocks out a debit. But what I'm saying is one starts with the debit, and in my respectful submission, there's no doubt that that debit, as a matter of language and without any ambiguity at all, must be 28.8 under Section 97. That debit corresponds to a credit of 28.8 million, which is the credit that falls to be taken account of by X Bank in respect of the interest on the gilts. And that's the way in which Section 97.2 operates. So that's the true correspondence of that 28.8 million. It's not got any true correspondence to the accrual of interest on the gilts as far as DCC is concerned. Its true correspondence is to create a debit to DCC of 28.8 million and a like amount as a credit to X Bank, which is in respect of the gilts. And with the greatest respect to Lord Justice Moses in particular below, there isn't any process of reasoning from the wording of these particular provisions to get to a result whereby you increase the accrual under the gilts loan relationship from 2.9 million to 28.8 million. There is nothing to support that in Section 84. Indeed, Section 84 is completely contrary to it because you're commanded to adopt an authorised accruals basis of accounting. And that gives 2.9, as Mr Holgate says, 2.9 or possibly 0. But what it certainly can't give is 28.8, and that's unchallenged evidence. So therefore, the construction of Section 84 can't get you to that result. The only other possibility is that somewhere in the wording of Section 97, Lord Justice Moses can divine an intention of Parliament to create a contra-edit credit in addition to the contra credit it's created as against X Bank, as against DCC itself in respect of its period of ownership of the gilts. And there's not a whisker of suggestion in the terminology of Section 97 to get to any such kind of result. And with greatest respect to the Lord Justice, it's invention. And also, to be fair, just to go back to the judges below, I hadn't dealt with the judgment of Lord Justice Ricks, and I should do. He, I think it's at paragraphs 94 and the end of paragraph 108. There are lots of observations I I could make about his judgment, but the first is that, and I can understand how this occurred, but it's in paragraph 88. He does demonstrate that he didn't understand the basis of the accounting that had actually been adopted in the statutory accounts, or indeed the nature of the repo transaction. I mean, you'll see there that he thought that as a matter of law, the beneficial interest in the coupons remained with the transferor, in this case X-Bank. Well, that's plainly not so. He's there confusing the accountant's in substance recognition of a loan with the legal analysis of the transaction. And that's in paragraph 88. And then he says in paragraph 94, these statutory provisions, although complex, are to my mind always seeking one goal, and that is, he says, which is to reflect the substance of a functional secured loan transaction, even though that transaction appears in legal form to consist of a sale and repurchase. And again, it appears, that, as I read, and I think this is also from paragraph 108, that you say that the totality of these provisions, the purpose of them is, as it were, to get you back to the economic profit. For the reason I've already given, that can't be said to be right. It can be said to be right of 730A, but not of 737A and section 97. And then he then goes into Mr. Holgate's evidence, and he sets out at paragraph 105 this quotation that the learned friend put in reply to the court, which Lord Justice Moses has been dealing with, and I'll deal with that in a moment. But at the end of paragraph 108, he says, or perhaps I'll just read the whole of the paragraph to be fair to him. In my judgment, the court's response to this evidence, this is the evidence of Mr. Holgate, in the context of the statutory inquiry, cannot simply be to accept the third answer, which does not even purport to address the statutory criterion of when taken together fairly represent. Now, the answer to the question, what is the credit to be accrued to DCC arising out of the receipt of the 28.8 million coupon, in the context of the repo transaction as a whole, thus taking into account the datum debit of 28.8 million, can only be 28.8 million. Only that answer reflects the totality of the statutory material, which seeks to recreate in its complex provisions the functional secured loan which the repo constitutes. Only that answer reflects the real evidence which I understand Mr. Holgate repeatedly to be given concerning the proper accounting treatment of these matters. Only that answer gives a sensible, realistic and just result. Only that answer can be said to provide the sums which, in accordance with an authorised accounting method, and when taken together, fairly represent all profits and interests which had to be taken into account. Now, my respectful submission, that last sentence can't be right, because that's disregarding the authorised accounting method. The first sentence, only that answer reflects the totality of the statutory material. In my respectful submission, it doesn't. It reflects 730A, but not 787 and section 97, which is the material that we're concerned with.
Where does he get the credit in the fourth line from? See at the end of the fourth line.
Yeah, it is, what is the credit?
That's what he's looking for.
Yes.
But where does he get it?
Well, that's the difficulty, my lord, yes. I mean, as I said a moment ago, you can't get it from the accounting evidence, because that says maximum 2.9. The only place he can get it from is that he thinks that's a fair result.
Well, I suppose he's reflecting section 84.1, isn't he?
Yes, that's the last sentence, yes. I suppose that's what he's intending to do.
But that is then to say, as it were, you've got a trump card in section 84. Forget everything else in section 84 about in accordance with an authorised accounting. You, the court, at the end of the day, have got to think what is the fair result if you've actually come to a conclusion you don't think is fair.
Apart from the error you detected in Lord Justice Ricks's judgment, is there anything in the two judgments that you disagree with apart from the use of section 84?
Well, probably not, no. At the end of the day, I would say of Lord Justice Moses' judgment, I mean, there are a few observations in the earlier part, But I regard his judgment as a Jekyll and Hyde judgment. It's Dr. Jekyll up until paragraph 68. It's all absolutely fine. Ideal analysis of all the statutory provisions. And then it goes into complete reverse when Mr. Hyde takes control from 69 to 74.
So 1 to 68 correct, 69 to 74 wrong.
Well, yeah. There are a few observations I might make about some of the early provisions. I might make them later, but they don't go to the heart of the matter.
But what do you say is in this appeal apart from Section 84 then?
Well, look, from our point of view, as a matter of construction at the end of the day, I'd agree with your Lordship. It's those 3 lines at the beginning of 84 coupled with the interest. It's a question of what those words actually mean, and can those words give rise to the consequence that the judge has said, Lord Justice Moses has supported, the learned friends support, that they give rise to a consequence that there is 28.8 million to be brought into account as an interest credit in respect of the holding of the gilts by DCC. We say that's an impossibility. The only amount that we brought in is 2.9 million. And I agree, at the end of the day, but what I've been trying to do, and I've been really slow about it, is to try and get rid of some of what we say are the irrelevancies that have actually crept in below. But, my Lord, your Lordship's put your finger on it. Where do you actually get that additional credit from? You can't get it from the accounting. It has to be magicked out of the air by some kind of reasoning out of Section 97, that Section 97 creates one debit of 28.8 million, a credit of 28.8 million to X-Bank, and an additional credit of 25.9 million to DCC on its holding of the gilts. Because that is what they've done. And as I said, to demonstrate that can't be right, that is out of the ownership of gilts for 6 months, giving rise to a maximum payment by the government of 28.8 million, to bring into charge to tax 28.8 million plus 25.9 million. And no doubt they'd say if it had been decided that the accrual on the gilts was not 2.9 million but nil, then they simply say, well, it's 2 lots of 28.8 million. But that's the fallacy of it. There is absolutely nothing in Section 97 that can work on Section 84 to increase the debit from 2.9 to 28.8. And I do say this is...
The expression "and when taken together" refers back to the credits and debits, does it?
Yeah, but you would have seen, I think it's in Section 80, they start by defining a loan relationship. And under this legislation, you've got to work out all of your loan relationships. And you've then got to work out your debits and credits in respect of them. And then you've got to aggregate them. Section 81 of the meaning of a loan relationship, subject to the following provisions of this section, a company has a loan relationship for the purpose of corporation tax wherever. So you then have to work out what loan relationships you've got. As I said, you've got 3 here. And you've then got to actually work out what are the debits or credits in respect of each of them. And then at the end of the day, you have to aggregate them. And I mean, there have been a number of examples of saying, when taken together, what that might apply. But what it would have to be is something which is consonant with an authorised accruals basis of accounting. So if for example, you've got, this is one of the examples given by the Special Commissioner, you might have somebody who in one relationship, which is perhaps mirrored by an indebtedness, in respect of the credit side of it, he might be accruing interest on a compound basis, but actually debiting interest on a simple interest basis. And the accountants might in those circumstances say, to give a true and fair view, you actually have to be consistent. And therefore, even though each of them might actually be a valid basis on its own, taken together, you've got to actually be consistent and have one or the other. And there are numerous examples from the statutory provisions that we give in our case of the meaning and content of those words fairly represent taken together. I mean, I'll come back to it, but I did actually, for my own purposes, make a note of all the various examples that we've actually given, which have actually been adopted in the courts below and in our argument. And in our case to this court, we deal with this point at paragraphs 145 to 160, particularly paragraph 160. But this point was accepted by Lord Justice Moses at paragraphs 64 to 65 of his judgment. And Lord Justice Reimer agreed with that at paragraph 85. Mr. Justice Norris agreed with it at paragraph 43 and 55. And in all our skeletons below, we've set it all out at a great deal of length. But I don't think for present purposes it's necessary for me to go to that. What I am saying is those words do have meaning, but they don't have meaning sufficient to override the rest of the words that they are enacted with. They are not a trump card to enable you to apply a basis different from an authorised accounting basis. And we say that, this is the more general point I was trying to make, and we say that the fallacy of the revenues approach is they start with the wrong point. They don't start with the words of the legislation and try and work out what they mean and what their purpose can be from the words. They just start from a desired result and say we have to get to that desired result. And that, with respect, I think at the end of the day, is certainly what the Special Commissioner did. And in my respectful submission, that's what Lord Justice Ricks did, and also what Lord Justice Moses did. Because when one looks for the analytical basis for increasing the credit of 2.9 from the words of the statute, you can't find anything. And all tax cases, one's got to start with the word of the taxing statute. I mean, that's the same as any case. I mean, I noticed when one of your Lordship's staff kindly showed us around this building, we noticed inscribed on one of the glass panels down below, under the title of Be a Justice of the Supreme Court, an explanation of what this required. And it commenced, and I quote, with the following statement: "You will start with the wording of any enactment."
I'm looking at the revenues case at paragraph 37, where the importance of section 84.1 is emphasised. And, well, as one would expect, they reject the point that you're making, that there's some sort of abstract idea of fairness which they're appealing to. And as I read it, they're emphasising that each individual credit and debit must be arrived at, computed in accordance with an authorised accounting method. So I think, with respect, there is an attempt here, and we'll hear obviously more from Mr. Furness when he addresses us, there's an attempt to probe into the language and find a solution in the language, rather than just some sort of overall sweeping approach. That's why I'm not for the moment inclined to accept that they just start off with an a priori idea and then just apply Section 84 in a loose way. So the argument you have to face is really a more structured one than that.
Well, I accept that's what they're saying there.
Yes.
But then I've read their case very carefully in the next few paragraphs, and I've been searching in the next few paragraphs as to where, as a matter of language, do they actually get to that result. I mean, they say it's not an overarching requirement of palm tree justice or whatever. Huh? But if they accept, as they must in my respectful submission, that we've actually given use and meaning to the words fairly represent and taken together, the question I would respectfully say must be for them as to how they can actually get out of those words a conclusion which is completely contrary to the other requirement of those words, that the matter has to be in accordance with an authorised accounting method. And all I can see that they've done in their subsequent paragraphs, it's paragraphs 40 and 41, it is to say that what we say it's paragraph 40. Paragraph 40, they say, at the top of page 21, on the second line, they say, DCC, Mr Justice Norrison and Lord Justice Reimer, reach a result which is contrary to accepted accountancy principles. And they say that repeatedly. But that, with the greatest respect, is completely wrong. That is to confound the error I was trying to deal with this morning. That is trying to compare three apples and their treatment on the one hand with the treatment of a pear on the other hand. The pear is the accounting treatment in the statutory accounts. That accounting treatment regards DCC as making an in substance loan. That is not a loan recognised by the loan relationships legislation. The nearest the loan relationships legislation gets to it is to get to a like result under section 730A, and that is interest of £1.8 million. Nobody's suggesting that that interest should be increased. They haven't suggested that. That's the only thing that's got any bearing on the statutory accounts. What one has to do with the other two loan relationships, the loan relationship evidenced by the ownership of the gilts, is to say, I have got, as a matter of legal concept and in force of the statute, an ownership of gilts for 18.5 days. What, in accordance with an authorised accounting method, do I bring into account in respect of that ownership? And the answer to that is £2.9 million. That's the answer on that loan relationship. On the Section 97 loan relationship, I've got a payment of 28.8 million away, which is a debit, and the whole of that accrues under that loan relationship. The aggregation of those two gives rise to a debit of 25.9 to set against the 730A credit of 1.8. But it cannot be a justified criticism of the judgments below or our case to say that applying the correct accounting principles to each of those loan relationships gives rise to a different result than you've got in the accounts. Because the accounts are looking at something quite different from the loan relationship under the legislation.
What would be the purpose of arriving at this result? In the mind of the draftsman or a putative draftsman?
The purpose, my lord, I think it goes back to this phobia that on these transactions, which the revenue would regard as being in substance loans, they didn't like the capital gains consequences. Therefore, they've leant over backwards to create income flows in respect of all of these transactions. And I would acknowledge that, and Lord Justice Moses, I think, acknowledges this, and take it to the minute, that they probably created too many income flows.
What would be the position, if X Bank were within the jurisdiction, how would it work?
Yeah. If X Bank were within the jurisdiction, it would undoubtedly have a liability in respect of the ownership of the gilts in respect of 28.8 million.
There would be a tax charge coming in on that side of the account.
That's right, Lord, yeah.
So, yeah.
That's unavoidable.
But just looking at that a bit more closely, assuming it holds the gilts for the other 164 days of the half year, then it would have a direct charge under section 80, 82, 84 on that proportion, roughly 9/10 of the actual coupon. And then in addition to that, it would have a notional interest flow under section 97(2)(b, would it not?
Well, subject to this, it may well have an answer to that on the basis of saying that in its case, the notional interest flow is simply representing a payment of interest as if it had received the coupon, and therefore that is simply a payment, whereas on an accruals basis, all you would bring into account would be the 28.8. So you wouldn't bring in two lots of 28.8. And that is the purpose of Section 97 2B.
Well, if you brought into account, I think that the figure is 25.9 million,
Yeah.
and you say that there's a direct tax charge and a charge on a hypothetical flow, is a bit odd then to say that DCC is treated as paying out 28.8 million, isn't it?
Yeah. That arises because of that distinct treatment in 97 of treating DCC as being paying under a fictional notional loan that's got nothing to do with the gilts, and then ascribing to the gilts the payment that DCC is actually making in the hands of Exbank.
But on the assumption that in quite a lot of these cases, both companies will be UK resident companies paying tax, what is a fair solution under 84? Well, you know the wording. Is going to take account not only of whether the result looks sensible or bizarre for DCC, but also for the bank, isn't it?
No, my lord, because I think that
No?
the bank, you see, the bank, yes, as far as, I'm sorry, as far as the bank is concerned, and assume it's held the gilts for the whole of that period, less the 18.5 days, the bank will then accrue 164 days worth of interest. And the other 18.5 days of interest, DCC will have accrued. So as a matter of legal analysis, the bank was an owner of the gilts for the 18.5 days. The mere fact that it's deemed to receive a payment of interest, because that's deemed to be received as a payment of interest on the gilts, that is simply a payment in respect of which it has accrued everything that it needs to accrue in respect of that payment of interest. So therefore its tax liability would be on 164 days worth of interest. I think that's the purpose of the difference in the subsection in section 97 between deeming it to be a party to the gilts and not to some freestanding loan relationship. If it were a freestanding loan relationship, then your lordship's point would be absolutely right. There would be two lots of liability.
Well,
But that I think is the purpose of it not being.
Freestanding is your phrase, isn't it?
Yes,
I mean,
absolutely,
it's not used in the Act of Parliament.
No.
I can see why you find it useful. Could I ask you another question, which is slightly different, but not entirely? Is there any definition of what representative of interest means? An adjective which is used a few times in the legislation.
I don't think so, my lord, but I'm not absolutely certain.
We have to work it out for ourselves.
I think so, yes. I mean, there have been a number of cases as to whether an amount that is paid, but ordinarily it's a contractual payment that is made so as to represent what the underlying dividend or interest payment is. And I'm really worried about that.
I'm sorry. I mean, just to take the really everyday example, that really is a normal commercial example. If you buy shares ex-dividend, and then because the paperwork goes through surprisingly quickly, you then find yourself on the register. And so you actually get the dividend check, and you're not entitled to any of it. And in due course, you have to pay it over. That is a manufactured dividend, is it?
Yes.
Yeah.
Because under the rules of the stock exchange, you're obliged to pay.
Certainly, yes. Yeah. And so in that case, there would be a manufactured dividend which simply represented a straight dividend that the seller of the shares or stock was entitled to.
Yeah.
Can I just go back to the point we were discussing minutes ago as to what the position would be if the bank were inside the jurisdiction? So what would then be the net effect so far as the revenue is concerned from your construction?
The net effect as far as the revenue is concerned is that as far as the coupon on the gilts is concerned, there would be tax of 28.8 million paid, 25.9 million by X-Bank and 2.9 million by DCC. As far as DCC is concerned, it would have a debit of 28.8 million to match or to mirror that coupon.
And that would therefore leave the revenue in what net position?
That would leave the revenue at disadvantage. That's the consequence of
With
the provisions of this case.
Would it leave the 1.8?
The 1.8 is brought into
Yes,
charge
sir,
as well,
anyway.
my lord, and also the 2.9. I mean, if I was making a comparison with the economic profit, the 2.9 shouldn't be taxed if that is the purpose of these provisions. Only the 1.8 should be taxed. But I mean, that illustrates the fact that these three loan relationships and the way in which they work out never actually end up with something equal to the economic profit. See, I mean, one of the problems of the taxation of the interest on the gilts is that they've disregarded the buying and the selling. But of course, anybody commercially will be taking account of the interest accruer in the prices at which he buys and sells. So that's all disregarded, and you've actually got to look at an accruer of interest without taking account of the buying and selling, because that's what the statute has done. And that's why I said below it. I mean, I don't run away from it. This legislation is and was a mess, and thank goodness it's gone. But the key to the whole case is, can one divine out of... I can see all the points your lordships are making to me, but can one see out of the words of section 84 or 97 a route to get to an answer in taxing the gilts that is in excess of an accruer of 2.9 million? And I do say, with the greatest respect for the court below, that you could only get to that by wanting to get to the result that you want to get to, not from the words of the statute, on any basis of construction.
Well, where do we go from here? That's the central theme of your argument, isn't it?
Yes, that's right, Lord. There were these three main points I wanted to make. The first preparatory one about the structure of the legislation, and I've made that already. This one being the language, and that Parliament hasn't simply provided for a consequence, which is just the economic profit. And then the third one I wanted, just for clarification, I already made this point this morning, but I'd like to just summarise it, because there has been confusion below between the actual accounting treatment and what the statute requires us to do. And this is the point in Lord Justice Ricks's judgment in particular. So the actual accounting treatment, as I explained this morning, in simple terms, DCC bought for 812, resold for 785, got a coupon of 28.8, made a profit of 1.8, and that is a situation whereby it's treated as lending 812 to X-Bank, and X-Bank is regarded in accounting terms as owning the securities throughout and receiving the interest throughout. That isn't a loan relationship, and isn't a loan relationship recognised by the legislation. There are the three loan relationships recognised by the legislation. The first is the real loan relationship on the gilts, whereby the government is the debtor and DCC is the holder, the creditor, for 18.5 days. As I said, as far as that loan relationship, applying to it an authorised accounting method, you can only end up with an accruer of 18.5 days interest equal to 2.9 million. And I've made my point that the rest of the period somebody else is having to accrue. If they're a UK resident, they've got to pay tax in respect of that accruer. The next loan relationship is the section 730A loan relationship, which we've looked at, a deemed fictional loan relationship, but whose result is to equal the economic profit. So 730A does that on its own. And again, Lord Justice Moses in paragraph 20 of his judgment makes that point. I'll just show you that very briefly.
Yes.
He's dealt with section 730A, one can see in paragraph 18, and refer to how it works out of the evidence of Mr. Holgate. He says in paragraph 20, had the statutory regime stopped there, the profit gained by DCC would have been charged a tax in a way in which any sensible tax regime might be expected to bring such a profit into charge, but the suit arises because the regime did not stop there. And we accept that entirely. And then, as I say, the revenue then have to find, out of Section 84, some kind of basis for increasing the credit on the guilts relationship. And as we see it, there's nothing in Section 84 that does that. It must be some kind of indirect operation of Section 97, which appears to be what Lord Justice Moses is saying.
Your understanding is that the revenue is seeking to find it in Section 94, not Section 97?
As I read Lord Justice Moses, my Lord, yes, Lord Justice Moses is saying in Section 97 you've got a debit which he accepts of being 28.8. He says that is a debit which represents the credit being the coupon. It is representative of the coupon. What we are looking at, he says, when we're taxing DCC under the coupon, is something in respect of the coupon. Therefore, when we bring in a debit of 28.8 into our Section 84 computation, he's saying somehow, because of that representative nature, we've got to bring in more credit in respect of the guilts. That is, I'll look very closely at those last few paragraphs of his judgment, but that is, I understand what he's saying. He's saying, and he's saying that's because we've got a debit, and it's not in the tax computation of DCC, reflected by a like amount of credit on the guilts. Therefore, we've got to increase the credit on the guilts. And he says, well, the 2.9 million on the guilts is displaced by the putting it together because of having to bring in the section, the 28.8 million debit. So it's probably an answer to your question. It's two things. I think he's relying on the 28.8 million debit being representative of the coupon because of 737A. And then he's saying, I'm taxing the coupon under this other loan relationship in Section 84. Therefore, I've got to actually increase that and displace the 2.9. And we simply say we can't see any justifiable basis for that. I'll come back to them, but it's the 3 points I touched on this morning. Firstly, it flies in face of the words of 84.1, because you're bringing in something completely contrary to an authorised accounting method. It's something else entirely. Secondly, the representative character of the coupon has actually been lost in the deeming process under Section 97. Once one's arrived at Section 84, all one is actually required to know, and all one does know, is that one's actually got a debit of 28.8 million by force of Section 97. And the third point, and this we say really does absolutely demonstrate that the process of reasoning must be fallacious, is that the debit of 28.8 million does correspond to a credit of 28.8 million, and that is a credit which is taxed on ex-bank and DCC. And therefore the correspondence in the legislation is quite clearly fulfilled, because there is a liability to tax on 28.8 million in respect of the coupon. And what Lord Justice Moses does is to create out of the coupon of 28.8 million a liability to tax on 28.8 plus 25.9. 54.8 million is created on the basis of his judgment as being the interest accruer in respect of the gilts for the 6-month period.
And that was a point he didn't spot for himself.
Yeah. Well, he seems to have spotted it earlier on, my lord. I mean, that's why I said it's a Jekyll and Hyde judgment. He's got that point right earlier on, but he seems to have forgotten it in the last 5 or 6 paragraphs of his judgment. Oh, no, I will take your lordship's entirely to the judgment. So the real gravamen of this, the third main point I was just trying to make, was that one's got to distinguish between the statutory accounts and the in substance deemed loan, which doesn't feature in the legislation at all, and the accounting treatment. So the accounting treatment of that has no resonance in the legislation. We've simply got 3 loan relationships to which we have, in each case, to apply an authorised accruals basis of accounting to each of them to arrive at the right answer. And this is the confusion I wanted to try to get rid of. When my learned friend, in reply, put this question and answer before the Court of Appeal, and Lord Justice Moses rejects any reliance on it by saying, well, this is just one answer out of very many, and no doubt it was subject to cross-examination, re-examination, and all the rest of it. But the point of it is this, that it was put forward as something relevant to the taxation of the gilts relationship of DCC.
Where do we find this in the judgment?
This is dealt with...
Page paragraph 30.
Lord Justice Moses, yes. Yeah. You will see if you turn over the previous page, what he's talking about is the taxation of the interest on the gilts.
Yes.
So that's the loan relationship he's looking at. And then we've seen that the underlying rationale in paragraph 29. And perhaps I better just read that and then go to paragraph 30. The underlying rationale of such an approach was central to the debate of this issue. Interest only accrues during the period DCC held the gilts because any vendor would expect to be compensated by receiving on sale cum div the proportion of the coupon relating to its period of ownership of the gilts. This read Mr. Holgate's report. As DCC put it, outside DCC's periods of ownership, others, including X-Bank, would have been parties to loan relationships with the government represented by the gilts, and would have been accruing interest in respect of the periods they owned the gilts. They would have to bring into account credits under Section 84 if they're within the charge of corporation tax. Then paragraph 30, the revenue contended that this approach is not applicable in circumstances to which paragraph 15 requires the price at which the gilts are sold and repurchased to be left out of account. This has the effect of treating DCC's acquisition cost and resale price as the same. The revenue sought in a written question Mr. Holgate's opinion of the correct accounting treatment of a transaction in which a gilt is purchased for the same price as it is resold and held for 7 days, during which the full amount of the coupon is received. Page 2, response to questions of 15th of January 2007. Mr. Holgate commented that such an arrangement was not a commercial arrangement, since the price would not reflect the receipt of the full amount of the coupon. But here I just pause here. This is being put forward as relevant to the taxation of the interest on the gilts in the hands of DCC. So it's looking at the first statutory loan relationship as being relevant to that. And as we'll see when we look at the actual answers, what Mr. Holgate is answering is in relation to the correct statutory accounting for a repo transaction. It's got nothing to do with the relevant question that's being looked at here. What Mr. Holgate says, if such a transaction were to take place, having already made the point that it's not commercial, then for financial reporting purposes, but not necessarily tax purposes, it would be accounted for in accordance with the substance of the transaction. That is, the company would treat the transaction as a 7-day secured deposit of X pounds, the acquisition and resale price, generating non-arm's length interest of £28 million. So if we look, I'd like to just sort this out properly, to look at Mr. Holgate's report and this question. But if we look at Mr. Holgate answering that question, the question he was asked was about the in-substance accounting treatment in the statutory accounts of DCC. So that, as I said, is to treat DCC as lending to X Bank. That is not a loan relationship recognised by the legislation. But that is what the question is aimed at, and that's what the answer is given as respects. But the question and answer were treated as being relevant to the taxation of the interest on the gilts, as somehow suggesting, and this has obviously got into the mind of Lord Justice Rix, it's quite fallacious, that somehow this suggests that somehow in this particular case you could bring into account a coupon of 28.8 million in respect of the taxation of the interest on the gilts. And that, as I say, is simply to mix apples with pears. This answer has got nothing to do with the accounting treatment that has got to be applied to the accruer of interest on the loan relationship represented by the gilts. This answer is 100% about the FRS 5 in substance accounting of the whole of the repo transaction. It's got nothing at all to do with what it was put up for. Now, Lord Justice Moses, for the reasons he gives, says he doesn't place any emphasis on it. Lord Justice Bryan agrees. But of course, Lord Justice Rix does pay a lot of attention to it, and it appears to be one of the mainstays of his reasoning. He refers to Mr. Holgate's evidence, and as at paragraph 105, he sets out the question and answer in full. He says, fourthly, Mr. Holgate was asked the following question and gave the following answer to it. And you can see from the question, it's paragraph 105 on page 27, Lord Justice Rix, so you can see the question, what is the correct accounting for the following transaction? So that's the question, and the answer, of course, is the in-substance treatment as if it were a loan by DCC. And you can see the whole of the answer. I mean, perhaps I should just read it. I'm assuming that other than the resale price of the gilts being the same as the purchase price, the remainder of the terms of the repo agreement in the above question are similar to those transacted by DCC in 2002, summarised in paragraph 3.2 of my report. In such circumstances, Company A would not be able to participate in any movements in the price of the gilt. It says the resale price of the gilt is fixed at the date of purchase, and the coupon receipt would not relate to Company A's holding of the gilt for the 7-day period of the arrangement. Rather, Company A has deposited X pounds for the period of the repo arrangement, which has generated a return, i.e. interest income. So that is the FRS 5 accounting treatment in the commercial accounts. Generated a return of interest income of 28 million, being the coupon received on the gilts, which Company A keeps under the terms of the arrangement. Clearly, such an arrangement is not an arm's length commercial terms, as X pounds being the market price of the gilt on the day of purchase could not generate a current market return equivalent to 6 months coupon on the gilt over a period of 7 days. However, if such a transaction were to take place, then for financial reporting purposes, but not necessarily tax purposes, it would be accounted for by Company A in accordance with the substance of the transaction. That is, Company A would treat the transaction as a 7-day secured deposit of X pounds, generating non-arm's length interest income of £28 million, with for the same reasons as set out in Chapter 4 of my report. Company A would not recognise an investment in the gilt as an asset in its balance sheet, as it does not bear any of the risks or rewards of holding the gilts. And then the Lord Justice says, what is the court to make of this equivocal evidence? Well, it's only equivocal if you've misunderstood the nature of the evidence. And with greatest respect to the Lord Justice, I mean, he has. I mean, this is part of the basis, and I'll come back to his judgment later, where he arrives at the conclusion that the answer that gives a sensible, realistic and just result is the 28.8 million. And with all respect to him, he's been misled there, because the 28.8 million in the example being put to him is the equivalent of the 1.8 million in this case. The example that was put to him was, say you've got a sale at X pounds, 7 days later, after receiving an interest coupon of 28.8 million, it's sold back to you at X pounds. It was a balmy transaction, but there you are. And you receive 28.8 million being the coupon. Do you bring into account in your accounts the 28.8 million? Well, of course you do, because that is the economic profit on that non-arm's length transaction. But that is the equivalent of the 1.8 million here, which is a subject matter of section 730A. It's got nothing whatsoever to do with the taxation of the interest on the gilts, which is the subject matter in which it was put up to support, which is the subject matter that Lord Justice Moses was dealing with, and which is the subject matter of the totality of Lord Justice Ricks's judgment on this. And it just demonstrates that one's got to be terribly careful in a case like this to differentiate between the commercial accounting on one side and then each of the three individual loan relationships, and then the accounting principles that one applies to each of those three loan relationships. And the commercial accounting is not applied to any of those three loan relationships, but most certainly not to the interest on the gilts in DCC's hands, and most certainly not to the deemed loan relationship under section 97. I mean, your Lordship took me to a learned friend's case, and I'd merely say, in response to that they disavow, and I can see them expressly disavowing, reliance on a freestanding, overreaching concept of fairness. But what I do say is, if one tries to analyse the paragraphs that follow in support of that, all they're actually saying is that somehow, and it's the point in paragraph 40 of their case that I've drawn attention to, that somehow we DCC, or me on behalf of DCC, Mr. Justice Norris and Lord Justice Reimer, reach a result which is contrary to accepted accounting principles. That is making the same mistake as they actually put up in regard to that question and answer to the Court of Appeal. The actual accounting in the commercial accounts has got nothing to do with the accounting principles that you've got to apply to each of the loan relationships. And therefore all that criticism is completely and utterly misguided.
Well, I'm not quite sure. There's a certain amount of repetition coming in your submissions, where we go from here, whether there's much more we need to take from.
Well, look, I'd like very briefly, and I apologise, I'd like very briefly to look at the statement of facts and issues, and then Mr. Holgate's report, because I think when you'll see from Mr. Holgate's report, you'll actually see how this all pans out much clearer way than perhaps it is in the judgments below.
Right.
And I'll obviously be very, very, very quick on looking at the statement of facts and issues.
Yes.
That's, I think, at page 1 of the core bundle. Yeah, under paragraph 5, 6 and 7, etc., it tells us what repos are, and I just draw attention to the third line of paragraph 6. Essentially, a sale and repurchase of both the sale price and repurchase price are determined or determined in advance.
We've had all of this.
Yeah, right. I'm very grateful for that model. And the only other point, it summarises in paragraphs 22, 23 and 24 the accounting treatment in the statutory accounts. And that's what I want to say about that. So it is actually summarised there, which is helpful. And then you will see under the heading loan relationships, perhaps I draw attention to paragraph 28, the first sentence, the repos are each transactions such as would be entered into by persons dealing with each other at arm's length. I should make that point. So they're ordinary commercial transactions in that sense.
Yes?
So we started off by dealing with the accounting treatment. Then under the heading loan relationships, you'll see, although they're not enumerated 1, 2 and 3, in paragraph 30, the 3 loan relationships identified under the legislation are identified in that paragraph. And then likewise, the issues, paragraph 31, identifies the same 3 loan relationships and setting out the revenues contentions in paragraph 32. So that's all I want to draw attention to there. But Mr. Holgate's report, I believe you will actually find helpful. It's in the appendix part 2. And it will clear up some of this confusion. Where is it? 2, 3, 4. At page 204. Sorry. And one can see there's a dichotomy, so that there are 2 things his report deals with, and you can see it in paragraph 1.2 on page 206. The first part of his report, he's dealing with the accounting that is actually adopted in the statutory accounts, the FRS 5 material. You can see 1.2, I've been instructed, etc., to provide an explanation of fixed price repos and description of how they are accounted for from the point of view of both buyer and seller in the financial statements. So that's the first part of his report, which is sections 4 and 5. And then he goes on, then explain what the appropriate authorised accounting method is in relation to the loan relationships, and he's then taken that from the statute, represented by the gilts for the purpose of the loan relationship provisions, and consider what debits and credits DCC must bring into account in accordance with that appropriate authorised accounting method, based on assumptions of the legal meaning of the relevant enactments in accordance with section 84. And that dichotomy is important because it's distinguishing between the actual accounting for the actual repo, that's the first 2 bullet points, and then he's identified the loan relationships and what the appropriate accruals basis is to apply to them. And you see that he's got a lot of experience and background and all the rest of it. I'm not going into that. Section 4, under the heading fixed price repos and their accounting treatment, at the end of paragraph 4.3, he sets out the key point that the accountants recognise, 5 lines from the end of the paragraph. Although legally a sale and subsequent repurchase of securities, the seller retains the risks and benefits of market price fluctuations of the securities rather than passing them to the buyer. Hence, such arrangements are economically similar to a secured loan, providing a fixed rate of return with the security acting as collateral. And then he has the heading FRS 5, and he sets out the key requirement of it, which is a quote in 4.4, a reporting entity's financial statements should report the substance of the transactions into which it has entered, In terms of the substance of a transaction, all its aspects and implications shall be identified, and greater weight given to those more likely to have a commercial effect in practice. A group or series of transactions achieves or is designed to achieve an overall commercial result shall be viewed as a whole. Therefore, he says, 4.5, FRS 5 therefore tells us to account for the repo transaction in accordance with its substance rather than its legal form, if the two do not accord. And then over the page, he refers to, at 4.7, application note B, which is the specific one applied to repos, requires analysis of all the features of the agreement from the perspective of both parties to the agreement to determine whether the transaction's commercial effect is that of a sale or that of a secured loan, and to account for it accordingly. This requires an analysis of who has the benefits and risks of the original asset, in this case the security. And then he at the top of page 216, he has accounting by the seller. So this would be accounting by X-Bank. So this is setting out the statutory accounting basis of X-Bank. And one can see it quite shortly in 410. If a coupon or dividend is paid by the security issuer to the buyer during the term of the repo arrangement, then the seller will benefit from such a payment as described above. Therefore, the seller should recognise as income the coupon or dividend payment on the security as though the seller had continued to legally own the security, even though the cash is received by the buyer. So let's say that X-Bank continues to recognise the interest on the gilts throughout, if you're a proper repo, as we are.
Yes.
And then if we go on, we'll deal with this very shortly, to page 219, accounted by the buyer, that's DCC. So paragraph 416, the FRS 5 analysis of the transaction as an in substance a secured borrowing and accounting for it as such is just as relevant for the legal buyer of the security. In substance, the buyer has lent, or in other words deposited, funds to the seller with the security as collateral. Therefore, in accordance with FRS 5, the buyer should account for the fixed price repo transaction as such. When under the repo agreement, the buyer must immediately pass on any coupon or dividend payment on the securities to the seller, either the buyer is merely acting as agent for the seller in this regard, then the buyer would account for the transaction as follows. The buyer would not recognise the security as an asset, even though it has legal ownership, it does not have beneficial ownership. The buyer would recognise a loan receivable equivalent to the cash it paid to purchase the security. And then the buyer would accrue interest received on its loan over the term of the repo rate, crediting the profit and loss account and increasing the loan receivable balance. The interest receivable would be equivalent to the finance cost payable by the seller on the same transaction and is in effect the economic profit on the loan. And then a summary of accounting treatment, page 221, 418. In summary, the seller accounts for a fixed price repo as a fixed rate borrowing with a related interest cost and continues to recognise the underlying security as an asset in its balance sheet. The buyer accounts for a fixed price repo as a loan receivable with related interest income and does not recognise the underlying security as an asset. And then he, in section 5, goes on to apply those principles to DCC's gilts ownership. And what he says, I mean, just to sum it up in 5.7 is the accounting adopted by DCC in respect of these repo transactions is in accordance with the accounting requirements on an accruals basis. In accordance with FRS 5 application note B, in my opinion, DCC correctly accounted for the repo transactions as a loan receivable, recognising the economic profit of each repo transaction in the profit and loss account in the period of the transaction. So that's all he says about the statutory financial accounts and the actual accounting. And then he goes on to section 6, where he's got to make certain assumptions. And those assumptions are that he recognises three loan relationships, which are the loan relationships I referred to. And so he recognises those. He refers in 6.6 to authorised accounting methods being either an accruals method or a mark-to-market. And then 6.7 he says, clearly therefore applying section 84 requires the application of accounting concepts such as debits, credits, profits, gains, losses, interest, accruals, basis, mark-to-market. Fairly represented is not an accounting term used within UK GAAP. Instead, UK GAAP is based on the principle that financial statements should give a true and fair view of the state of the entity's affairs at the balance sheet date and of its profit for the period. 6.8. The Statement of Principles for Financial Reporting, issued by the Accounting Standards Board in December 1999, describes the four principal qualitative characteristics of financial statements that help determine the true and fair view as relevance, reliability, which includes faithful representation, comparability and understandability. From an accounting perspective, I would expect fairly represented to have similar characteristics. Indeed, the IASB's framework for the preparation and presentation of financial statements, which contains a common set of qualitative characteristics with those in UK GAAP, notes in paragraph 46 that the application of these qualitative characteristics and of appropriate accounting standards normally results in financial statements that convey what is generally understood as a true and fair view of, or as presenting fairly, such information. Thus, there is no significant difference between giving a true and fair view, presenting fairly, and fairly represents. And then he has the heading section 84 and paragraph 15. Then he deals at paragraph 612 and paragraph 15. And he then sets out sections 737A, 616, and then 619, 730A. And then he deals more significantly in section 7 with the exercise posed by section 84. So he's recognised the three loan relationships that we're concerned with as recognised in the legislation. And then he sets out what is an authorised accounting method under 7.2 onwards, and I don't think I need trouble with that. And then 7.9, debits and credits are brought into account under section 84. And then the heading on page 234, under the heading DCC, section 84 and paragraph 15, he says, I'm assuming that DCC has not entered into the repo transaction with Ulster Bank, and hence there is no investment in the guild. So this is on that assumption, and we've now formally said that we don't rely on that assumption anymore. And he says in consequence of that, you would arrive at a zero position for the gilts. But more significantly over the page, under the heading Scenario 2, and this is the scenario that Mr. Justice Norris concluded was correct and we've since adopted. I mean, it was our alternative argument before the Special Commissioner, but it's the only one we rely on now. The 715, if it is assumed that DCC has invested in the gilts on the date of the sale and disposed of its investment on the date of the repurchase through the transaction with Ulster Bank. However, the debits and credits arising in respect of the transaction with Ulster Bank, either sale and repurchase, are ignored, which just leaves the coupon receipt on the gilts to account for. Hence, DCC has a loan relationship with the government in respect of its investment in gilts, but no related transaction for the purposes of Section 84. Then he comes to his first conclusion. He says, well, there'll be no income represented. But then 717, he says, alternatively, if one assumes that we ignore the debits and credits arising on the acquisition and disposal of the gilts with Ulster Bank, but it is still necessary to account for the legal ownership of the gilts, being the loan relationship, and the position is as follows, and here are his 2 points, is 718 and 719. He says, as DCC did not acquire and sell the gilts with the government, there are no gains and losses on disposal of the gilts to take into account under Section 84 in respect to DCC's direct relationship with the government. However, DCC held the gilts at the coupon date and so was entitled to receive an interest payment from the government in respect of its investment. From an accounting perspective, applying the accruals basis as defined in FRS 18, paragraph 27, it is appropriate to bring into account the interest accruing on the gilts only in respect to the period those gilts are held by DCC, either a proportion of the interest received by DCC. This is because any other party holding the gilts before and after the term of the repo transaction would expect to be compensated by receiving the proportion of the coupon relating to their period of ownership of the gilts. So 719, therefore, under this assumption, in my opinion, the sum which fairly represents the interest arising on the gilts held by DCC, ignoring any purchase and sale proceeds, is the accrued proportion of the coupon for the period of the repo transaction. In accordance with an accruals basis of accounting, it could be no more. Specifically, DCC could not recognise the receipt of the full interest coupon unless the gilts have been held for the full period to which the coupon relates. And of course, the Special Commissioner accepted Mr. Holgate's evidence in paragraph 11 of his decision. But that is critically saying that in accordance with an authorised accruals basis, you could not bring in anything more than 2.9 million. So the conclusion arrived at by the majority of the Court of Appeal here, it flatly contradicts the requirement of an authorised accounting basis in section 84. And then he goes on to deal with section 737A and section 97 loan relationship. But that's the significance of his evidence on the accruals basis as far as the interest on the gilts is concerned, I've just dealt with. So here under 737A, he says, I'm assuming that section 737A and section 97 have the effect of deeming there to be amounts of interest equal to those set out in paragraph 19 of the appellant's statement of case, equivalent to the gross amount of the coupons on the gilts received by DCC during the repo terms, to be treated as paid by DCC under a loan relationship. 721 on this basis, DCC would have paid interest equivalent to the cash coupon received on the gilts in respect of a loan relationship. No more is known about the terms of such a loan relationship, but given that DCC is deemed to have paid interest, it must be assumed that it is in respect of a loan payable, i.e. a liability of DCC. And he says in footnote 10 there, note this contrasts with the actual repo transaction, which is in substance a loan receivable by DCC, i.e. an asset. And then 722, he says, from an accounting perspective, it is not possible to determine the debits and credits to be brought into account in respect of any deemed cash payment that fairly represent the loan relationships, unless one has more information about the transaction. For example, the premium on redemption of a deeply discounted bond will be taken into account to determine the interest accruing on such a bond for an accounting period. However, without knowing the full terms of the transaction, it is not possible to determine whether the deemed interest does fairly represent the interest accruing on the loan relationship and related transaction of any for the accounting period. But then he goes on 723, he says, however, if there is a legislative need to determine the debits to be brought into account on an accruals basis that fairly represents the loan relationship, then I would understand the legislation may be making an assumption that the deemed interest, which is to be treated as paid by DCC under a loan relationship to which DCC is a party, was payable in respect of a period for which DCC was a party to that loan relationship. If that is the case, then from an accounting perspective, a debit for the whole amount relating to that period should be recognised in respect of that accrued interest payable.
What are we to take from those comments? I'm not quite clear why you're reading these out to us. What is the point you're trying to make?
Yeah, my Lord, it's simply this, that if one is right that as a matter of statutory construction of section 97, what we are told is that DCC is the only debtor to the loan relationship that it is a party to and pays interest of 28.8 million under that loan relationship, that it would follow in accordance with an accruals basis of accounting on that statutory hypothesis that the whole of the 28.8 million is deductible. That's the only point, my Lord. But it is actually quite an important point. It's the one picked up by Lord Justice Moses in the paragraph 51 that I showed your Lordships earlier this afternoon.
It's probably getting pretty close to the borderline of what is a proper subject for expert evidence from an accountant, isn't it?
My Lord, I haven't read you the earlier parts, and he does actually recognise that. He said, look,
Oh, yes,
to give answers to this, I've got to make some
Yes,
assumptions.
I wasn't being critical,
No.
but it strikes me it is pretty near the borderline.
But he said, I've got to make some assumptions to try and answer the questions. And he's saying that I'm making these assumptions. If I'm wrong about the assumptions, then obviously my evidence doesn't stand. And all I'm saying about this is that if you actually look at those assumptions, as a matter of law, as a matter of statutory construction, those are the correct assumptions to make of Section 97.
He does say, to be fair to him, at page 211, paragraph 3.4, that he can't comment on the interpretation of the legislation. So he's not offering that.
That's right. And all we're relying on is what I've just answered your Lordship, is that if that is the correct construction of the legislation, then this would be the accruals that would follow.
Yes.
That's all.
Yes.
But it's an important point to make that, as I said earlier, one's got to leave on one side the statutory accounting. One's got to start with the legislation of looking at three legal concepts, legal relationships. One's then got to work out what are the constituent parts as a matter of law of each of those loan relationships. and the facts relevant to them, and then you apply the accruals basis of accounting to those facts. And that's the relevance of Mr. Holgate. You've then got a section under 730A and 737C, and that's all agreed.
Yes.
As I said, the economic results, I don't think I need read that. And then he sets out his conclusions. 8.2, he simply says that DCC's financial statements are drawn up appropriately, etc., in accordance with FRS 5, and they recognise this in-substance loan. He then deals with, under the heading section 84, and in 8.5, he says that the credit on the gilts interest could either be nil or 2.9. And he says in 8.6, on an accruals basis, for it to be appropriate to recognise the whole amount of the coupon as a credit in DCC's profit and loss account, I would expect DCC to have held the gilts on a beneficial basis for the whole of the coupon period, i.e. 6 months. And he says if you make similar assumptions made from the perspective of Ulster Bank, then under both scenarios, Ulster Bank will continue to recognise the income in respect of its holding of the gilts, other than in the repo term. So that's the point that I made, I think, this morning. That is that Ulster Bank would recognise the gilts and accrue 25.9 million, and that added to the 2.9 million would represent the whole of the 28.8 million. And that is it. The only other point that you might find helpful is on page 246, when he gives a glossary of terms and abbreviations and the definition of accruals. At the top of page 246, FRS 18, Accounting Policies, paragraph 27, describes the accrual basis of accounting as requiring the non-cash effects of transactions and other events to be reflected as far as is possible in the financial statements for the accounting period in which they occur, and not, for example, in the period in which any cash involved is received or repaid. And the whole of that, and I'm not going to go to the whole of FRS 5 note B is at 252. The question and answer and cross-examination, re-examination, I'm not going to take your lordships to it now. I've made my point on it. I mean, it simply serves to confuse. It is confusing the actual statutory accounting treatment with what we've actually got to do, and that is to look at the loan relationship represented by the gilts and apply an accrued an accruals basis to that. So that really, and that unfortunately I think led Lord Justice Ricks into error. That then I think can take me on quite a long way, if I can revert to our written case. I have, as I said, I wasn't proposing to say anything about our section A, which is paragraphs 1 to 33, because I think I can make those points as what one goes through. As far as section B, the significance of the case and the background and the details of the present case, I think I've covered everything that I want to say as far as that's concerned. Likewise, section E, DCC's statutory accounts, and I dealt with the relevant statutory provisions this morning. The form and structure of the legislation, I've made my points about, but I would like to draw your lordship's attention to the decision in Mawson and also to Lord Hoffman's lecture, which has 2 or 3 little points in it which I think might be helpful. We deal with this in so I'll just sorry, I've just lost where we do deal with it. It's the significance of the present case And we touch on Mawson in the footnote and refer to it later, and we refer to Lord Hoffman's article. This is in our case, this is paragraphs 37 and 38. But Mawson, if I could ask your lordships to look at Mawson, it's in the Authorities of Volume 1. It's at tab 9. My Lords Hope and Walker were parties to this case, and I'm only looking at it for points of principle, but I could explain that the facts of the case is actually relatively simple in a sense. A subsidiary of Barclays Bank bought, in effect, the pipeline running from Scotland to Ireland, providing natural gas to Southern Ireland, and leased it back to the vendor. So Barclays Bank was, in effect, coming along as a finance lessor, buying the pipeline from the vendor, leasing the pipeline back to the vendor that was required to pay lease rentals under the lease back, but also requiring that as security for the payment of those lease rentals, an amount equal to the purchase price, £91 million, paid for purchasing the pipeline, should be deposited with Barclays, or deposited with a depositor to the order of Barclays. And the real argument of the revenue was, well, all the money really went round in a circle and nothing ever really happened. It was all a Ramsay-type argument. And their Lordship's House came to the conclusion that looking at the terms of the statute and construing the terms of the statute, what the statute required them to determine was whether the Barclays subsidiary had incurred expenditure on the pipeline, expenditure of a capital nature. And that was the relevant question, and construing it that way, they came to the conclusion that it had. And it's just really for the general statement of principles that I wanted to just draw your Lordship's attention to. So I don't think that one would help a great deal by saying any more than that.
Seems to say that taxing statutes have to be construed in accordance with the same principles as any other statute.
Yes, yeah, that's absolutely right, Lord. I mean, there's been some suggestion, particularly by Lord Steyn, that tax law has been living in a world of its own for the last sort of 70 or 80 years, and I personally wouldn't necessarily accept that, but that's what Lord Steyn said, so I've got to accept it, I suppose. But it's merely saying that one's got to approach the construction of the words of the statute, having regard to their purpose. And
That's nothing very revolutionary.
no, not at all, my Lord. I wouldn't say revolutionary at all, but it's to get over to some extent the pre-existing feeling that there had been after Ramsay and Furness and Dawson, that somehow there was something special about this approach towards tax cases. And what Mawson does is to put us back onto the straight and narrow of saying it is actually all a matter of statutory construction, albeit that you've got to construe the statute having regard to its purpose. And I don't need to draw, it's a judgment delivered by Lord Nichols, but to which all members of the House had actually been a party. And perhaps if I could just invite your Lordship just to look at paragraph 32, just the whole of paragraph 32, and it might be worthwhile just reading paragraph 36 to 39.
Well, we can perhaps read this for ourselves.
My Lord, yes.
suppose the essence of the point you're making really is the first sentence of paragraph 39, is it?
Of which paragraph, my lord?
39, first sentence.
Yes. It's a starting point. I mean, one starts with the words, one makes a close analysis of the words, trying to determine what their purpose is from the words, what the statute actually requires. And it was to get rid of this suggestion in the past that somehow Ramsay had put us into a different kind of world, away from statutory interpretation. It was some kind of philosophy about composite transactions and the like that meant you didn't need to look at the statute.
Yes.
I mean, just in that context, there's Lord Hoffman's lecture, which is right at the back of Authorities Volume 2, and we quote a little bit of it in our case, but it's basically to the same effect. It's Divider 25 at the back of Authorities Volume 2.
There's a passage that you quoted in your case, isn't there? Is there more to it than that?
There are just 2 or 3 points, but
Right.
they all go to the same point. And I think perhaps just picking it up, if one could look at page 203. The primacy of the construction of that last break of particular tax provision, the illegitimacy of rules of general applications, has been reaffirmed by the recent decision of the House in Barclays, Mercantile Finance and Mawson. And he says similar things, but I won't bore you with it, over the page at the end of the first paragraph, over the page, and on page 205. And we've quoted the passage on 205 anyway in our case. I mean, he says, for example, at the end of that, on page 204, first break, there's a paragraph beginning with the first question, and then after referring to Lord Templeman in the previous sentence, he then begins a sentence towards the end of the page, towards the side of the page, but how do we know the intention of Parliament? There is only one way to know the intention of Parliament, and that is to read the statute. And it's really in that vein.
Yes.
So well, that's covered a lot of our material.
Well, looking at your contents on page 2 at the beginning of the case, you seem to have covered pretty well everything now.
I've got up to section G, my lord. What I haven't done is actually sort of section G,
Yes.
where we do refer to 2 cases. One is the Bank of Ireland case, and one is the Darcy case. So G starts under paragraph 120, the formal structure of the legislation. I don't want to say anything more about the Darcy case other than what we've quoted in paragraph 131. I mean, the facts of the case and the circumstances that arose, I mean, aren't about repo transactions or anything of that nature at all. Well, Lifford is right, actually. There is a repo in there, but it's not at any points that actually we're concerned with in this particular case. What Mr. Justice Henderson was saying there, well, there is something that's arisen here that rather unexpected. It gives the taxpayer a substantial debit, etc., but that's from the interaction of these 2 quite different statutory provisions. That's all we're saying there. The Bank of Ireland Britain Holdings case, I would like your lordships to look at, because that is a repo case. It's on section 730A and deals with 737A as well. But the real significance of it is that my learned friend ran exactly the same kind of argument in that case as he's been running here. Because in that case, he said, what you end up with in this particular situation is a situation where you've actually made an economic profit, but you've claimed a very substantial debit. That can't have been the intention of the legislation. And therefore one's got to get to a result, as it were, that achieves that. The Bank of Ireland is...
It's tab 11,
Tab 11
in volume 1.
Because of the relevance of it to the statutory reasons, I think it might be worthwhile reading a fair amount of it. But if I could perhaps just summarise what the facts were to start with, I think that might help.
What is the proposition which you're citing it?
The proposition one citing from this report is simply this, that it's not good enough to assert that you should end up with a result that is equal to the economic profit. What the case demonstrates simply is that if you're looking at these repo provisions, they are closely articulated provisions with a defined target, and at the end of the day, you've actually got to construe them in accordance with their terminology, and if you end up with a result which is favourable to a taxpayer or disfavourable to a taxpayer, that is the result of the statutory provisions. As my Lord Collins at the end of the day say this would be an impermissible gloss on the terminology of the provisions. You are stuck with the provisions that you are stuck with, in effect.
Most of the relevant material is in paragraph 129 of your case, isn't
Yes,
it?
I would have thought so. I mean, the crucial point in the judgment is really quoted, isn't it?
Yeah. I mean, we've attempted to summarise 42 to 46 in that paragraph of our case. Well, I accept that. All I'd really say, though, is that if one looks at it, we are concerned with the provisions that we're concerned with in this case. That they are given the meaning that they actually mean as a matter of language, and the Lord holds you can't put a gloss in, you can't read words in here that they don't actually sustain, and that's what you're stuck with, and that, we say, it is the right approach in this particular case. So if I put that then to one side, I'd then like to go on to just look at our case where we do deal with the two issues and make some comments, some of which I've already actually anticipated in what I've said. We deal with issue 1 under heading H on page 42 of our case. In paragraph 134, we set out the three loan relationships. And 137 on, we set out what comes in on an accruals basis. And I've shown your lordships this, and the only point I just draw attention is what we draw attention to in paragraph 140 on the basis of Mr. Holgate's evidence that specifically DCC could not recognise the receipt of the full interest coupon unless the gilt's been held for the full period to which the coupon applies. And then we go on to make these various points about Lord Justice Moses' judgment. And again, I'm not going to repeat those, and I think I've already made them. But I would actually like to just go through Lord Justice Moses' judgment once to pick up a few points in the earlier part that one might actually not necessarily disagree with, but possibly sort of elaborate on, and then just make some comments about the last part of his judgment.
Well, would it be better to undertake that exercise tomorrow morning in view of the
Yes.
time?
Yes, I think that's...
How much longer do you expect to be?
I wouldn't have thought, my lord. I mean, one of those rare occasions, but I think the estimate we gave was that we didn't think I'd be more than an hour tomorrow. I don't think I will be. In fact, I would hope at the moment I'd be less.
Very well. We'll rise now and see you again at 10:30.
My lord, I'm obliged.